with his information, his intro. He's in court.
Oh, is he? Okay. I'll still, I guess I could still say hello, but just say he's in court.
Okay, that sounds great. Dave, it looks like we have a quorum. Would you like to start?
Yes. Good afternoon, everybody. I'd like to call to order the Board for Indigent Defense Services here in the state of Nevada. It is February 2nd, good Lord, 2023, and just about 1 o'clock. Cynthia, if you want to do a little roll call here, or if we've already done that and you know we've got a quorum, just let me
No,
know.
I'll go ahead and do the roll call.
Thank you.
Just want to let everybody know it's being recorded. And Chair Dave Mendiola,
Here.
Vice Chair Laura Fitzsimmons,
All right, here.
Joni Eastley, Chris June Kiliani, Jeff Wells, Drew Christensen,
Here.
Kate Thomas,
Cindy, it looks like she just signed on. If you want to.
oh, okay. Lorena Dellinger,
Here.
Commissioner Hall,
I'm here.
Allison Jaffe,
I'm present.
Harriet Cummings,
Here.
Jared Hickman,
Here.
and Justice William Maupin. We have 9.
Cindy, I'm here. This is Kate Thomas. Sorry, it took me a minute to join.
No problem, Kate. I gotcha.
So sounds like we're good to go. Very good. So let's move on. Second item is public comment. And of course, public comment period is limited to comments on items on the agenda. No action can be taken upon the matter raised until the public comment period, unless the matter itself has been specifically included on an agenda as an item, as an action item, but may be discussed by the board. So are there any public comments? Did we have anything online?
Dave, we did
we have-
not receive anything additional other than the letter which we've shared from O'Melveny, which has been provided to all the board members. And I see Franny Forsman has her hand raised.
Okay, yeah, Franny, it's the floor is yours.
Thank you, thank you. I'm appearing or speaking on behalf of the litigation team in the Davis case for the plaintiffs, O'Melveny and Myers and ACLU and I. We laid out pretty clearly, I think, our position with regard to the executive order from the governor and we urge this board to advise the governor that we should be exempt from this executive order, both Section 2 and Section 4 on 3 grounds: public safety, judicial deadlines, and compliance with federal law. I don't think that this agency is what the governor was thinking about when the executive order was issued. We're a new agency. We have, I don't know, Marcy, I think it's about 40 regulations. We're certainly not overly regulated. But most importantly, I think, and I was racking my brain and talking to John Lambros, if we could think of another agency that was created in order to enforce a constitutional right, and that's us. And so we're urging the board to take the position that no regulation should be cut at this time.
Thank you very much. Appreciate that. I was going to ask you before you said anything, Franny, if you wanted to just wait until the item, but now that's out there, that's good. I'm sure we'll have plenty of discussion around that. So,
Chairman, could I ask a question, Allison Jaffe?
yes, please do.
Because Ms. Forsman just had a limited time and it's public comment, we can't ask questions. Can we, when we move to that portion of the meeting, can we go ahead and ask her our questions at that point?
That was my expectation.
Okay.
So, yes. All right, so let's move on to item 3, approval of minutes, approval of the December 8, 2022 minutes. Has everybody had a chance to look at those? Are there any comments, edits?
I just wanted to say that these were beautiful minutes. Everything was just totally laid out, and I really appreciate that. So I didn't see any problems with it at all. It was great.
I agree. They were really easy to read and well done. So good deal. Do I have a motion for approval?
Mr. Chair, I'll move to adopt the minutes as proposed.
Got a first?
I'll second that.
Thank you. First from Drew, second from Allison. All those in favor say aye.
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 Any opposition? Looks like that passed. Move on to item 4. So introduction of the Nevada State Public Defender, Chris Arabia. Unfortunately, Chris is doing his job. He's in court right now. So I would like to welcome him on behalf of the board. And we're thrilled and would like to congratulate him. And he's got a big challenge ahead of him, but we believe he'll be up to it. So anyway, but I was going to have him say a few comments, but he's not available for that. So we'll move on to item 5. Discussion of the executive order 2023.003. And so I'm assuming everybody's had a chance to review that executive order, as well as some of the instructions related to that. And of course, Marcy has provided us a list of potential things that we could consider. I guess what I would like to do is I do want to have input from the board and any questions to Allison's earlier request to ask a few questions of Franny. But in looking at this and just doing my own research, I personally feel like I would agree with Franny that, you know, there's some exemptions here. I agree that I don't think this particular department was the focus of this executive order, especially considering the fact that it grew out of, you know, the judgment. And so it's my personal opinion that I don't think we should consider anything, but I am certainly open to comment about it. And with that, I think I'd like to start off with Marcy. And Marcy, would you like to do a little preamble to this and then we can open it up completely?
Yes, thank you, Chair. We did receive an executive order 2023-003, which we've shared with all of you today. And in this executive order, they have paused our ability to make regulations, and they have asked every board to undertake a comprehensive review of all the regulations subject to their enforcement, and that on or before May 1st of 2023, each board shall prepare a report for the governor's office detailing how the regulation subject can be streamlined, clarified, reduced, or otherwise improved to ensure the regulations provide for general welfare of the state without unnecessarily inhibiting economic growth. So today we are set for a public hearing to review our regulations, and they have asked that every board provide a list of not less than 10 regulations recommended for removal, ranking them in descending order of priority, and that they are asking that we hold this public hearing for that comprehensive review, that we vet recommended changes or deletions, solicit input as to the merits of the changes, identify other regulatory changes we think we could make, and that we select not less than 10 of those to recommend to the governor. So that's the purpose of our hearing today. I've also provided a copy of the initial instructions, which were prepared for us by the governor's office, and you have a copy of those as well.
Thank you. Appreciate that. So I guess what I'd like to do is I think it's important that we establish the public hearing because we are going to be talking about this. And so with that, I think what I'd like to do is, Jared Hickman, would you mind giving us some background? You were in the middle of this from day one in terms of the building of this department and setting up regulations. And I'd love to hear your thoughts, and then we can go around the horn and talk with everybody.
Sure, and thank you, Chair. You know, I would say I certainly agree with Franny and the letter submitted by plaintiff's counsel. When Marcy and I and Tom and to some extent Patrick undertook to write these regulations, I think we paid very careful and close attention to not only our authority granted by statute, but also the requirements of the consent decree. And so, I think the 42 that we have are including the definitions, some of which were submitted by the department for consideration for repeal, were all necessary and very narrowly tailored to both the scope of authority and purpose. In reading the letter from plaintiff's counsel and the executive order, I guess I would have a question that is probably suited to Deputy Attorney General Long. I see that there's exemptions, the three exemptions for the ban on new regulations. But the question I have is, can we, as a board, having considered the regulations and public comment, can we decide not to proffer any for the chopping block, so to speak?
So I do think that is appropriate, considering, first I do echo what Franny Forsman said previously, But second, if you only have so many regulations and they're all necessary for via statute and consent decree, there's not much that can be on the chopping block, and you are a new agency. So, I mean, again, 40 regulations, and if you try to take away 10, and you don't really have 10 to offer. So I do agree that the response could be, there just aren't any.
Thank you, Jared, for passing it on to Sylvia. I appreciate that. That was one of the things I wanted, was to get a comment from the DAG, and so appreciate that very much. Having said that, it's my sense that again, I think you made great points. First of all, we don't have a lot of regs, unlike those that have been around for a long time. I don't think we've had a chance to make them difficult on the public. And so, but I think it's a good warning. I commend the governor on the plan to look at everything. I think we should do that. I think it's important that we're always looking internal to find out what we can do better and can we make things more efficient. So I appreciate the governor's efforts on this, but I would agree that we are so young, and again, it was born out of the consent decree. And so I think, to me, it's very difficult, even with the definitions. Part of me suggests that the definitions are really good because I don't have to go out and look at NRS to find out what something means. It's all in context of the regulations in one spot. So anyway, so having said that, I'll get off my platform here and allow other comments. So tell you what, I'll just open it up to the board. I think, Allison, you said that you definitely had some questions. Why don't we start there with you?
Thank you, Chairman. I would like to echo your thoughts that I understand why the governor is doing this, and it's probably actually a really good idea that all the agencies self-audit. So I think it makes a lot of sense, and certainly we have. But I wanted to ask Franny about with the consent decree, does the executive order really have the ability to override our requirements from the consent decree?
Oh man, that's not a question I expected.
Okay.
Yeah, now I really don't have an answer for that.
Okay.
As to whether or not I don't have an answer to that.
Okay.
As opposed to guessing. Yeah.
I'm just thinking that the court has jurisdiction, and we, it was kind of a big long-term commitment for everybody to come to the consent decree, and everybody agreed to it. And I don't want to risk that, because, Davis is basically what we're about, to increase the quality for our defense of our clients.
Well, I can tell you, to the extent that the executive order will make it more difficult for the consent decree to be carried out, and I think even the recommendations from Marcy Riva, to the extent that they make it more difficult for the clients, the attorneys in the rural counties to be able to comply with the executive order, I'll guarantee you that if that happens, that then they will be back in the court.
Right. Well, I just appreciate where we are, and I think the rural attorneys that I've talked to, and the experts, agree that, this used to be a long, drawn out process. You had to get a court order for everything. If I wanted an expert, often the judge would invite the DA in to my ex parte hearing. I mean, it's just, and it would be, of course, on law and motion day. So I'd be last at 11:30 if I was lucky. But I just think that what we have is respectful to our mission. And I appreciate that Marcy, gave us, okay, this is like skin and bones. This is what we could do, but I think we have to respectfully decline.
I do want to point out that we've had 6 reports from the court monitor. And what comes out of those reports is that there really is a need for more regulations, in order to be able to carry out the intent of the consent decree.
Mhm. Thank you. Thank you, Chairman.
I see Drew's got his hand up.
Yeah, Chairman, I just wanted to bring up a point that Franny said, which is interesting in the sense of, the regulations in this board was created to assist a roadmap of constitutional requirements that quite frankly existed prior to this. But our board and the roadmap that we've developed is in essence the Davis lawsuit to help us follow through and make sure those constitutional requirements are being met throughout the state. So, I think it's a step backwards because the constitutional requirements were always there, but because of some lapses, this board was created of the various, previous boards that got to this point where we have it now, is meant to assist those attorneys who have the responsibility to provide in the state, the responsibility to provide the constitutional requirements in the first place. So I'm supportive of, what the Attorney General had quoted, that I think we can get an exemption just because of the newness of the board, the constitutional requirements that quite frankly, the board is tasked to make sure evolve around the state. And so I'd support that position of asking not to take any of our regulations away. And perhaps, depending on how long a stay is on existing regulations, there's a possibility we may want to amend some that we have and add new ones as we find issues that develop around the state.
Thank you, Drew. Anybody else like to comment? So if I have no takers, I guess the only other comment I'd make, and I think it's,
Dave?
oh
I'm
yeah,
sorry
go ahead.
to interrupt. I see Harriet Cummings has her hand up.
Okay, Harriet.
Hi, I have just a question for clarification. Ms. Long said, as I understood it, that we could say we had reviewed the regulations and had none to offer. And is that a distinct, separate procedure from seeking an exemption, or is that just 2 ways to state the same thing?
Question.
Well, I think there are 2 different procedures, right? Because one was proposing new regulations that you can get an exemption if you want to push new regulations through. And then the other was looking at 10 of the ones you already have and trying to, and proposing which ones can be, I guess, deleted.
So we could be doing both. One or the other, or both.
Well, correct. I think you're doing both, except I don't think you're proposing new regulations at this time.
Right.
Right.
Thank you.
Yeah, thank you, Harriet. That was a good question, because I had a similar one. So as I was reading through the executive order under exemptions, there's section 5 D, and it states that regulations that affect the application of powers, functions, and duties essential to the operation of the executive branch agency, department, board, or commission at issue. So to me, that means that's our exemption right there. Because that's who we are and what we are, and without them, we're back at square one.
And Dave, too, this is Marcy for the record. I think we could also say regulations affect pending judgment deadlines, that's subsection E, because we do have specific requirements. We are in the process of creating our workload standards, and we are required to create that as a standard by regulation, and that counties must comply within 12 months. So to comply with deadlines in the Davis judgment, we will need the ability to do that. We believe this also falls under B, that it affects public safety and security, as if we don't have a public defender present to represent an individual charged with a crime, then possibly charges could be dismissed. or we don't know the outcome of what the court could do, but it could impair public safety.
Yeah, so I guess my question, to go back to Sophia, my question then is, can we simply prepare a letter stating our belief that we have an exemption under the items just discussed and leave it at that?
Yeah, I think that's fine. I think that that's, you know, in your letter, that's why you're not proposing any to be cut.
Okay. Thank you for that. Does anybody else have a question or want to comment?
Chair, I just want to also point out for the record that, like Jared said, when these regulations were being created, we very conservatively created these regulations, but there are certain things in statute that we were required to create. So in NRS 180.320, we were told by the legislature that we had to adopt regulations. For example, requirements for specific continuing legal education and experience. These are contained within our regulations. Requiring attorneys who provide indigent defense services to track their time, and that they had to comply with the regulations. That is in our regulations. Establishing standards to ensure that attorneys who provide indigent defense services track and report information in a uniform manner. Again, that's in our regulations. Establishing guidelines to be used to determine the maximum caseloads. This is the regulation that we need to create once we have our maximum or our weighted caseload study completed. In the meantime, we do have a regulation that it informs them that they need to withdraw if they're not able to handle the case. We were required to ensure consistency and representation. So we do have a vertical representation regulation. We also have to ensure that recommendations for a manner in which an attorney is appointed may request to receive expenses for experts and investigators. Again, that's set forth in the regulation and now through Assembly Bill 480. And then finally, that we have to establish by regulation a maximum contribution formula. So we have complied with this, and although we have authority under subsection 4 to adopt any additional regulations that this board deems necessary or convenient to carry out the duties of the provisions of this chapter, we did not at this point add any additional regulations that fall outside of what we're specifically informed to do, because we wanted to take that conservative approach because of feedback we were receiving.
Thank you. Well, that seems to me that needs to be part of the letter to support that position of an exemption. But could you also, Marcy, comment on the business impact survey as well?
Yes, in preparation for this meeting, since it was being held as a workshop, we were advised by Dag Long to prepare a workshop notice. And before you can do a workshop notice, we have to do a small business survey. We had a limited amount of time from the point where this meeting was going to be scheduled to the point that this notice had to be put up on the website. And when we reached out to each of our public defenders, we provided a survey asking them whether or not repealing any of our regulations would affect their businesses. We received four individuals responding to our survey. One person said that their small business would not be affected by a repeal. A second person said, nearly 60% of the firm's cases opened during 2022 were indigent defense matters. Changes to NAC 180 would limit access to counsel for indigent defendants or would decrease the incentives to provide zealous representations. It would affect our small business by making bids representation less viable. Due to economic uncertainty, it's not clear that the firm would be able to make up for the loss of business by emphasizing other practice areas. Additionally, the firm recently entered a contract with both parties contemplated the current bids regime with Lyon County to be the tertiary public defender. Changes to the regulation could impact performance of that contract. A third respondent says, I believe this will have a tremendous negative impact on small Nevada law firms. Currently, there's a shortage of public defenders in the state of Nevada, in particular the rural counties. Part of the shortage is due to the compensation. These lawyers are paid and living in the rural counties of Nevada, and it's not for everyone. Based on my limited understanding, the goal is to change the law and bring lawyers from other states that make less money than the current public defenders in Nevada. This would defeat the whole concept of the Davis lawsuit and would take jobs from licensed Nevada lawyers who have small business in the state and who employ citizens of the state. I am against bringing in unlicensed Nevada lawyers to take jobs from qualified Nevada licensed attorneys. Thank you for your consideration. And finally, the fourth response is the repeal of the regulations could slow down needs and payments for investigative use.
Thank you, Marcy. Are there any questions about that business impact survey and the respondents?
No, Mr. Chair, this is Christian Kiliani. I just wanted to note I am on. I was in the dentist's office and I couldn't, I was unmuted. So.
Well, we're glad you're done with that. So thanks for letting us know that, Chris. Appreciate it. So I guess, oh, is there anybody else? I hear something.
Yeah, I don't know if you can hear me. This is Laura Fitzsimmons. And
There she
I,
is.
of course, agree with everything that's been said. And I understand that basically, based on the executive order, my understanding is that Marcy, or I guess there's going to be a motion and a vote, but seems like Marcy's going to be submitting a written request for exemption. Is that right? And I would just ask that it include, I'm sure it will, Marcy, because you're so thorough, the points you've made, the letter from O'Melveny about the litigation, and whatever input our DAG wants from the AG's perspective about, you know, justifying our exemption. Is that kind of what you're looking at?
Yes, I think that's a great idea, Laura.
Mr. Chair,
Yes, go ahead, please.
so, sorry, and I could be the only attorney in the room interpreting the executive order in this manner, but when we're talking about submitting a request to not repeal any of the regulations that come from Section 2, I don't think that needs an exemption. I mean, we can explain why we're not repealing, or we're not proposing any repeal. But as far as Section 5 goes, I think Section 5 only pertains to, which is, you know, the section regarding the exemption only pertains to proposing new regulations, which this commission is not.
Thought
Okay,
it was
thanks for that
4 and
clarification.
5. I'm sorry, I'm looking at it. It's 4 and 5. I don't care how it's, you know, how I obviously I defer to you, Ms. Long, but just however we do it, I think those things need to be provided to the governor's office. I think we all agree that for a lot of boards, this is a great executive order and it's long overdue. You know, so we're supporting it, but for all the reasons that we've stated, whatever relief we're requesting, that we're not going to do it or we want an exemption. I think we need to explain it so it just doesn't, so that he sees and his staff sees how deeply we've looked into this and what an exception we are.
Thank you, Laura. So it sounds to me like we are in pretty much agreement that number one, we don't want to make any new regulations. Number two, that we don't see a possibility of changing or doing away with any regulations because of so many things, you know, stated by Marcy with respect to the NRS statute that it was built on. So having said that, my guess is we're kind of leaning towards that. It looks like Chris wants to talk here too, but let me just finish here, Chris, that maybe we move towards, you know, motion for a letter from Marcy signed by myself to the governor's office with our reasons for why we did not consider changes. But Chris, I'll let you go first.
Thank you. You pretty much summed it up. I was going to ask if you as a chair wanted to have a motion. I think everybody's in consensus on this. We're a new agency. The regulations are imperative to us carrying out the new duties that we have. And, you know, we still have the lawsuit hanging over our heads if we decide not to follow some of that. So I think if you would like a motion, I would make a motion that we draft a letter that Marcy reiterate along with our DA, our AG, and any points as to why we either need to qualify for an exemption or will not be able to repeal any of our regulations.
I will accept that motion. Do I have a second?
I'll second.
Thank you, Jared. I've got a first and motion and a second. Everybody understand the motion? Very good. All those in favor, signal by saying aye.
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 Any opposition? Hearing none, the motion passes. And so I guess the next question then would be on, we're actually in the workshop itself. I see no reason to go into A, B, and C. Would that be your understanding as well, Marcy?
Yes, I agree. And it looks like Sophia agrees as well.
Very good. Thank you. All right, so we will.
Chairman, could I ask, since we are unanimous, I would like to have the vote be noted that it was by unanimous vote and consensus with our board.
Yes, that's a great idea. So noted. All right, so we're going to move on to item 7, budget and legislative update, and I'll turn it over to Marcy.
Thank you. So we had some really good news at Interim Finance this week. We had some pending requests for funding for Douglas County, White Pine County, Elko, and for the first time Humboldt County. So the total amount of that was around $101,000. We appeared before Interim Finance and they unanimously agreed to move those funds into our account so we could reimburse our rural counties. This will be the close of fiscal year 22 funding. And with this close, we have reimbursed over $1.9 million to our rural counties. So that was some excellent news that we had at that Interim Finance. There was a great topic of conversation, which when we get into our governor recommends budget, I'll move into that as to what the future of that maximum contribution formula is. Moving on to the next, B is fiscal year 23 Q2 county reporting. I've provided what we have for reporting to date. At the end of the second quarter, no counties have reached their maximum contribution formula. Some issues are Douglas County has not reported their second quarter. We've reached out to them to inquire what's happening. They recently had a changeover in their appointed council administrator, so we think this might be part of the reason they're delayed in providing us with this. Lincoln County did provide us with reporting. It was late reporting, so we have noted that. And Story County is in the process of giving us county ledgers so that we can verify what expenses they said that they had paid. And you'll notice that there's new reporting. Lander County for the first time has reported a quarterly report. So Tom and I will be working with Lakin and Bert Ramos in Lander County to talk to them about what they need to submit to get in Q1 reporting. And they are contemplating whether they'll be asking for reimbursement for fiscal year 23. So that's exciting news that Lander County is starting to report, even though it's not necessarily required unless you are asking for a reimbursement. And I can take any questions if there are any on the fiscal year 22 or fiscal year 23 expenses.
This is Chris, if I might, Mr. Chair. I just think that's an excellent report in that it shows good faith on behalf of DIDS reimbursing the rural so that they're not left hung out there. So it's much appreciated that IFC did that.
Thank you. Appreciate the comments. I agree. That's a tremendous report. And I think some of the more information that Marcy's going to share with you, I think is even more exciting, and she'll get to that a little bit. So I won't spill the beans for you. But thank you very much. I'll turn it back to you, Marcy.
Thank you. So moving on to the governor recommended budget, what the governor has recommended for us has changed since his state of the state. So the one change is what was brought up at Interim Finance yesterday, and that is that the governor's office is going to be putting forward a one shot in fiscal year 24 and another one shot in fiscal year 25 of $3.5 million in each year. So that's a total of $7 million that will be set aside for the maximum contribution formula for reimbursement purposes. My understanding is that the governor's finance will be writing these one shots that if all the money isn't spent in fiscal year 24, rather than going back to the general fund, it will roll over into the fiscal year 25 account. As for fiscal year 23, which we're currently in, we all know that we don't have these expenses within our budget at this point in time. We do have the $1.2 million that was set aside in the interim finance contingency account for the Davis counties, but we didn't have any money to reimburse our non-Davis counties. And when the legislature's in session, you can't go to IFC. So the governor did recommend an allocation of $2.5 million. So that's the 2.5 plus the 1.2, which will be provided to our department in fiscal year 24 so that we can start reimbursing those fiscal year 23 expenses. And I don't know the exact dates of when we'll get the 2.5 million. It depends on whether that supplemental appropriation is approved by the legislature and when it moves into our accounts. As for the Department of Indigent Defense Services account, we at this point are basically status quo other than the maximum contribution formula. The governor's budget does recommend one new management analyst too. We have expressed concern that the amount of workload that has been placed on us with the change of Assembly Bill 480, where our department is assigning or selecting counsel for cases and processing billing, it is creating a substantial workload. We looked at the numbers, and in calendar year 22, our department assigned over 2,100 cases. We processed over 400 bills for criminal cases and over 400 bills for post-conviction cases. So this is a large amount of workload that's been placed on us, which wasn't in existence prior to AB 480 coming into effect. So this is part of the stress on our department internally, is we need additional staff to be able to help with this. My understanding is this management analyst too will assist with the maximum contribution formula and will assist with collecting county funding and auditing what they're reporting to make sure that it's accurate. We also have some funding to replace some computer equipment and other things. So those are the two additions to our budget from where we were. The state public defender, if he were here, I was going to talk about his budget. His budget has been increased because they've added a White Pine County office. As we all know, White Pine County has opted in for representation, and the White Pine County office will consist of one chief deputy public defender, one deputy public defender, one investigator, and one legal secretary. The concern is staffing the office, whether we'll be able to staff the office with the salaries that the state public defender's office can pay. And I think that's something Chris was going to touch upon. Other areas where we've received an increased recommendation in their budget is the governor is recommending the budget to include $100,000 for our complex litigation unit. I don't know if you recall, but some counties have opted into representation and death penalty expenses for the complex litigation unit. Those counties are Churchill, Humboldt, and Lander. Of course, White Pine County, Carson City, and Story County are fully opted in, but those 6 counties have requested representation in death penalty cases. So the $100,000 will be used for an opportunity to contract with counsel if necessary. And my understanding is that at this point in those 6 counties, there are no pending death penalty matters. So those are the big changes for the public defender's office and our office. I'm sure that some concerns we may hear from when we hear from our monitor, Professor Evenon, are that we did not receive any sort of policy personnel. You may recall that this board did support our request to have 2 policy personnel that could work under Tom Qualls, who could go out into our rural counties, watch courts, see what was happening, and help get the word back to us of what we're seeing day to day. That was not built into our budget at this point in time. And again, that is an area that we are required to do, is systematic oversight of each of these counties. And we are limited to Tom, Peter, and I to complete that. So with that, I can take any questions on our budget.
So anybody would like to jump in here?
This is Chris. Is that 100,000, is that for each year or is that over the biennium?
I believe that's for each year.
Okay, because yeah, you could easily get that if they get a case.
Yeah, and I would point out, just to let you know, Lyon County has a pending case. In the first 2 quarters, they've reported spending $86,000. The first 2 quarters of this year.
Wow.
I wanted to jump in too and ask a question, or kind of discuss with Marcy. I know we've had two of the folks in the public defender's office leave, maybe one more. And I know at least for 2 of them, Sally Soto and for Chuck Odgers, they've both left the office and are now they're earning more money than they did with us. Chuck is at the DA's office in Douglas County as a deputy, not a senior deputy. And he's earning at least the same or more that he earned as the senior deputy at the public defender's office. Sally Soto is in Washoe County in the appellate division. She's earning more. I just think we really have to focus on, getting our staff more money. It's just obvious that they are underpaid, even for other public service lawyers. They're, always underpaid. They're just, steps below. And I just really want us to make that our focus.
Yeah, and Chair, I do see Chris Arabia has come to the meeting. The one thing that I would point out is that this board did see the report from Mitch, our data analyst, and he said that we're far behind county and municipal for payment, but that we're also far behind what they're getting paid at the Attorney General's office. And he pointed out that his concern was that there's different duty levels and a differentiation in the pay. So we had requested to have pay parity with our Attorney General's office, and that is currently not built into our budget moving forward. This does bring concern because as we're going into White Pine County is a Davis County. And if our public defenders aren't on par with what the prosecutors are making, that's specifically required as part of our regulations and the stipulated consent judgment. And I'm sure Eve can express if she's got a concern with that, but that's something to be brought up. And I think Chris will say he got notice that another public defender is leaving, and this time to go to the Attorney General's office. So his office of 9 will be reduced to 6 very shortly.
Yes, and I'd like to jump in for a moment if I could, Marcy. I'm sorry I'm late. I was in court in Virginia City. It ran a little bit long. I'm glad to be here now. I caught some of what Marcy was saying, and obviously, I agree with it. We do have an issue when our pay is considerably lower than even the comparable people who are in public service who aren't making top dollar, as Ms. Jaffe pointed out to start with. And, we're working on White Pine. That's certainly a top priority. I also have to take care of business locally, which I'm happy to do, getting into court and whatnot. But yeah, it's going to be an issue, and I'm hoping that we get some kind of relief on that. The money that's been allocated doesn't really seem to be enough, and that's going to cause bigger problems down the road if we don't get them solved now. Since I didn't hear everything that preceded this, I'll limit my remarks to that for now. But yeah, and thank you, Marcy, for stepping in.
Hey, thank you, Chris. Earlier, I was going to introduce you and congratulate you on the new position, and even offer you an opportunity to make any initial comments. And so if you'd like, just to say a few things, let's do it now, and then we'll get back to what we're talking about here.
All right, well, thank you. I am the new state public defender. I'm very happy to be here. Carson City has been a little colder than I expected, but it's very nice up here to spend a extended amount of time in a different part of the state. And like I said, I've been in the mix in court, and I'm really looking forward to the challenges ahead. My background shows I believe very deeply in indigent defense, and I've worked at it for a long time. I'm happy to be in a position where we might be able to make some long-term changes, and to, you know, kind of consider this sort of a jumping off point for complying with Davis, and for giving people who don't always have the best of opportunities a chance to be on something resembling an equal footing when, you know, sometimes their liberty, even their lives can be at stake. So I've gotten into all the different things that are going on up here. And as I said, what Marcy was saying is, you know, she could have been speaking for me, certainly, because, you know, all the niceties about doing good and everything else are great, but people have to make a living. And if we're not competitive, that's going to be a problem, especially in a situation such as Ely, where, you know, we're kind of building sort of a new office. And that's, like I said, a challenge, something that I'm looking forward to. But in an overall sense, I'm very happy to be here, and I'm very grateful for the opportunity. And I think that's it. So thank you for the opportunity to speak, though.
Thank you, Chris. Appreciate that very much. So let's kind of get back to the topic. And I think, you know, pay, we've had these discussions before, but I think it's time that we put together a strategic plan. And I guess no time like the current, because we have an opportunity with a session starting here to get to the people that we need to. And I've had several discussions with legislators, and they were very receptive to me. And I just think that we need to use all of our resources and our connections to get out there and make people aware of what our challenge is with respect to pay, not only internally, but externally. And so I think that's a big thing. I would love any comments on that.
And you know, Dave, I do see Chris's hands up, but just so the board members realize what kind of money we're talking about, to bring these changes into the pay parity we were requesting would cost around $160,000 each year. So a total of $330,000 or so would bring us over the biennium, would bring us competitively with the Attorney General's office. And then for our counterpart for the policy, what we had set forward was a policy staff of attorneys that could go out, a travel budget, and the estimated cost of that was $379,000 in the first year and $467,000 in the second. And that would be the 2 attorneys plus an administrative assistant plus someone to help us assign the cases with our large caseload of that 2,000 cases being assigned.
Thank you. So I think just with those numbers in mind, you know, as we reach out to individuals, I'll come right to you, Chris, in just a minute.
No problem, no problem.
With those numbers in mind, I think, you know, I mean, let's not kid ourselves, they're significant. But they're also, they go back to the basic issue of providing the kind of service that we want for indigents. And you cannot have the discussion unless there's a financial piece part of it. It doesn't just happen because you say it should happen. So that would be my comment. Chris, I'll turn it over to you.
Thank you. I think it's actually so long overdue. I mean, state employees, state management, they've never been compensated appropriately. And we train them, we spend the money to train them as a state, and then they go to local government or they move out of state. So I think this is the year that there is an influx of money. Gaming just got, you know, another new huge win as far as some new numbers that came in. And I think at a minimum, we should fight to get the on par with the Attorney General's office. That's really not a bad dollar amount if you think about it overall. The 2 traveling attorneys and that to assist, again, we have a statewide program. I think we make a request, maybe we do it by resolution as a board saying, you know, we understand, but here are some issues that we have to deal with. And we've already lost 3 people. And the governor's aware of how short they are. I think there's something like 1,400 short just state employees across the state. So try to realign that and emphasize that the board is is in support and that this is the year to fix that part of it because they do have the revenue. Yeah, granted, it'll be in roll-ups, but that's just the way it goes as far as budgeting process. And you know, you can always have a fallback position. If we could get the salary equity and maybe one attorney in 1 year, the second attorney ramped up in the second year, you know, with the staffing. There are just other ways that could be looked at financially with IFC or Senate Finance. But I think it would be helpful for maybe a letter from the chair or the board that, you know, it's not just Marcy and her staff asking, it's us in agreement with that part of it. Thank you.
Yeah, thank you, Chris.
Mr. Chair, if I can just follow up. Chris, that's really good information. I actually think that we need to take the lead on this, not Marcy. As I recall, and I can't wrap my head around all the bits of the roles that she has, but I understand, Marcy, if you make a request and it's not included in the governor's budget, that there's some, I don't know, etiquette or a policy or something that you kind of, you work for the governor, so that's that. Chris, I think we need to do this as a board, and if the chair would be willing, to actually send the letter. And then the second part, which he mentioned, which our chair mentioned, we need to get out and talk to whoever we know that's in the legislature. I don't want to wait for interim finance on this, right? I mean, this is something, and Chris, you know much more about this than I do, but basically, wouldn't we go in wouldn't we do the groundwork and then go in to the hearing when the DID's budget is discussed and ask for an augmentation for these purposes?
Yeah, if they
Isn't that
haven't,
what we did?
Chris, if they haven't changed the process since I've served, and it's been a while, that you can't put staff in that kind of a weird position because technically they're under the executive branch, so lobbying against would get them in trouble or for something. It probably would make good sense to have the board take a position that we all sign on to a letter, and then we find out who, they're doing the budget hearings now just to educate all the legislators, but we should be prepped to go in and testify when the hearings come up.
Yeah, so I would agree with that. I think it needs to be a united front, and I think that certainly, Marcy, you can help us put together, our talking points. And I don't think we can take any action on a resolution today, although I guess Daglong is that not true?
Oh, I'm sorry. I was shaking my head because you can't.
Yeah, that's what I figured. So, but I think that we can, I'm happy to take the lead and put a letter together. I don't know, again, I think we would need the vote of the board if we're going to do it as a board. So that may have to come back at another meeting, whether that be special or otherwise.
Mr. Chair, this is Chris. Could we do a special meeting like in 2 weeks and do it by phone? And then that way we'd be almost in time and sync with what the ledge is doing.
Yeah, that was my thinking. Yeah.
Chair, just so that you know, I can give you the dates where we're scheduled to do presentations. February 8th, we'll be presenting in front of the Assembly Committee on the Judiciary. February 9th, we'll be in front of the Senate Committee. And February 24th is when we'll be presenting our budget.
Okay. So I would suggest, if we could do a special meeting here in a couple weeks, so that we can get approval of a resolution and or a letter or both. And that way we've got something as a board to take in, to the hearing.
Marcy, I'm sorry to have you repeat yourself, but could you hit those dates one more time?
Yes, so the dates are February 8th for the Assembly Committee on the Judiciary, February 9th for the Senate Committee on the Judiciary, and February 24th for budget. And I don't know, Daglong, if you could let us know, do we need to have a special meeting, or could the chair be authorized to communicate with the legislature on behalf of the board as we've set forth in 7 subsection E subsection 4? in our agenda.
Actually, I think that's acceptable as long as you give them the parameters to discuss.
Okay, so we can do something within that context then. Okay,
And so we could do something today, which would authorize the chair to communicate with the legislature. And we wouldn't have to wait, because thanks for Jared asking for those dates again, because they're like, the first two are like right around the corner. So I think this is good. I think I ask that this be done as soon as possible. I know Marcy, really can't and shouldn't present this, but she, she can certainly present the information to our chair to incorporate in a letter. Do you agree, Ms. Long?
I'm sorry. I feel like you cut out a little bit. Can you
Probably
repeat
did,
that?
and I don't, I hope it's just me, because you're all cutting out. Yeah, basically what I'm saying is, as soon as Marcy can get the information to the chair and he can put it, in some talking points and in a letter, but also something that, is just out there for the assembly hearing and the Senate hearing before the budget. I mean, it'd be great if that could be done very quickly, because those meetings are coming up very soon.
Yes, and as long as this discussion right now pretty much hits on those talking points, so the board is fully apprised pretty much as far as what the chair is going to communicate with the legislature.
Okay.
So can we just say that what we're agreeing that the chair could talk to legislators about is the on behalf of the board, and maybe indicate that the board is again unanimous, is the $160,000 for the staff increase, and did you say 330,000 for the policy? Marcy, I think that was the amount.
379 in the first year and approximately 467 in the second. So it is the policy unit, the pay parity with prosecutors, and whether or not this board has concerns about the complex litigation unit, whether $100,000 is sufficient. And I know Eve is here. I don't know if she's got anything she would like to add that maybe this board would like to consider placing in that communication.
Yeah, thank you, Marcy. So much has been said already and said well, but when I look at the judgment, what I see is that the state's done so much to comply with what it can comply with, and the department has done a great deal. And the things that are left out of the compliance picture are almost all due to inadequate funding. So the judgment requires oversight and support on fairly specific matters around representation, making sure that there's client communication, but rapid appointment, assessments of indigency, rapid appointment of counsel, conversations between counsel and their new client that are confidential before a bail hearing, that absent good reason, no substantive rights are waived at that first appearance, and so forth. So you can imagine, how can a small unit like DIDS ensure this in 10 diverse rural counties? Well, the only way really is to have folks who can go out, and the plan really that would comply is this plan, which is in the regulations as well, that there's a once a year at least real check on each county, and the ability to do spot checks and appear and make sure that things are going smoothly along the way. And then part of that too is the training budget, which is really quite low, to provide opportunities for training in the different issues that come up. I know that in some areas, just finding attorneys who meet all the qualifications has been a real challenge. So the department has had to find mentors for newer attorneys so that they can take cases and be trained to take higher levels of cases. But that requires budget as well. So I really think that the department's ask here is, it's minimal, and I think it would be enough, but they're really asking for less than probably what ultimately they will need to meet those requirements of the judgment. Another piece of it, which I don't really know if this is part of the budgeting process, or it seems that it ought to be, right? But is just the amount of inefficiency of having to go to the IFC every time a county needs reimbursement, and then acting as a sort of intermediary with the counties to say, can you report this a little bit differently? The IFC wants it differently. So lacking control of the budget is to reimburse is an inefficiency, I think, which takes up time, Marcy's time, takes up the department's time, which could be remedied if that budget's just in the control of the department. So then finally, we have the state public defender. And if I remember the numbers correctly for Ely, I think they have cases, I think they've had 3 or 4 attorneys working fairly high caseloads, reporting a lot of case hours as well, work hours. So I guess I'm a bit concerned with how the state public defender will fare if they only have a chief and a deputy attorney there. Whether that'll be too much. And I don't, I haven't talked to Mr. Arabia yet about the budget out there to see what that is, but it is a Davis County too. And then complex litigation, I guess it depends on the number of death penalty cases, but certainly doesn't seem like enough if there's even for one death penalty case, but if there's more than one death penalty case, it's going to be insufficient. I'm happy to take questions. My audience really reports to the court. But as I, do this work, I hope that it will be helpful to you as well, to the chair and to the board in making the case.
Thank you. Appreciate that. Yeah, I know. I think it's very valuable, certainly from my perspective, that it's kind of that constant reminder that what we're here for and what we're lacking at this point in time. And I agree with you that it does go back to funding. And again, you can't have the discussion without there being a cost related to it. I don't care what you're doing. So anyway, I appreciate that information. So Marcy, do you feel like you have captured and can help me craft a letter so that we can get that to the legislature in a timely fashion?
I forgot one thing, apologies. I just wanted to add that the pay parity with the prosecutorial counterpart is in the judgment. So this question of pay parity for the department and certainly Eddie Davis County is part of the judgment too.
It kind of aligns with the same thing we're talking about with respect to the the executive order too. I mean, it all aligns. So it only makes sense that we continue to push that button. So Marcy, I'll go back to you again and ask that. I'm pretty sure you've got your arms around this. So
Yes, I feel that with that information, I can assist you in preparing that letter for the legislature.
Okay. Very good. Do we need a motion for that?
Yes, please.
Thank you. So I will entertain a motion to prepare the letter.
This is Chris. I'd make the motion to draft, to have the chair prepare a letter with the assistance of Marcy and others with regard to the item on the agenda on the budget parity issue.
And this is Allison, and I would second that motion.
Got a motion first and a second, and any questions about the motion? If none, all those in favor signal by saying aye.
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 Any opposition? Hearing none, motion passes. So that's great. So Marcy, I'll turn it back to you and you can continue forward.
Yes, so then on the upcoming legislation, to update you on our bill draft request, we know that we have our policy bill, Senate Bill 30. The purpose of this is to protect the attorney-client privileged information that needs to be turned over to us because of data or because we are approving requests for billing or that we're approving requests for expert or investigator fees. The purpose of this is to create this exception from the public records request to us to ask for that money to be provided. And thank you to Drew for this idea, because it's my understanding he's had a similar experience where prosecutors do try to get this information to learn what their counter is doing. So we are trying to make sure that that is protected. Our budget bills have not moved forward at this point in time. Budget is not required to be filed with the legislature until February 17th. So I don't have anything to update you as to whether or not our budget requests have moved forward or not. And I can keep the chair in the loop as to what we learn on that. Again, I've told you that we're going to be going in front of the Assembly Committee and the Senate Committee. We have been asked to present our Senate Bill 39 in front of the Senate Committee. So hopefully they'll be able to vote on it next week and start moving that forward to try and get it passed. At our last meeting, Member Jaffe asked about whether or not our department could have a lobbyist. And what we've learned with talking to our DAG Long is that we are not allowed to use public funds to employ a lobbyist. Our department is allowed to educate any sort of legislators that ask us what certain things are doing, but we aren't allowed to lobby. Whether or not the board members, like Laura has set forth, want to go, you are permitted to do that, but we cannot employ anyone to do that. And that's our update for all of Part 7.
Great, thank you. I do want to just quickly go back and to see if Professor Hannon, was there anything else you wanted to provide? You were kind of commenting on our issue around a letter or reaching out to the legislature, but I don't know if there was anything else you wanted to add to the update on the monitor report.
Yes, I'm working on it right now, and I guess perhaps I would just like, I'd imagined perhaps commenting on the budget in writing first. I'm a little bit behind my own schedule there, but I'm going to try to do that over the weekend so that you'll have something from me as well, if you'd like. Again, it'll be addressed to the court as an update, an interim, kind of an interim update on the budget issue, but I do want to be timely about that. So that's all that I have.
Thank you very much. Appreciate that. All right, so we're going to move on to item 8, oversight update. Tom's going to give us the update on that, and I'll turn it over to you.
Thanks, Chair. It's been a kind of long meeting already, so I'll try to make this short. In your packet, there's the Q2 fiscal year 23 quarterly data report. We are getting reporting from every county now, and every county seems to be doing a better job. It's more thorough, it's more complete. We're continuing to work out the bugs with the reports prior to publishing it. So that's making good progress. Again, that's in your, I won't go through that. It's in your packet. If anybody has any questions, you can let me know. As for the oversight update, I sent Professor Hanan a sort of multi-county update on January 11th. That's in the packet. I just wanted to hit a few highlights and some, expand on a couple of things. Carson City, we have great faith in Chris. We're super happy that he's here, and he's got great ideas, and he communicates with us all the time. And so we think that the NSPD is in great hands. The issue that he's facing right now is that a third of his attorneys are soon to be open positions. So he's he's like 30% open right now. We're incredibly frustrated with the budget news, you know, as have been addressed here, the parity, the fact that what was originally pitched as potentially a 20 or 26% across the board salary increase now looks like an effective 4% increase, which in my opinion isn't enough to attract anyone. So that's the deal. We've got these open positions in the NSPD here in Carson City and Story. We're concerned. We were concerned when White Pine opted in because we thought they're going to have to kind of, you know, attract maybe some Vegas attorneys, and you know the pay scale is much higher there, but we were hopeful with the parity and the projected salary increase we could do that just fine. So now we're kind of looking at a different situation in White Pine County as well. I don't mean to just be a wet blanket. This is not usually the kind of report that I am here to give, but we were joking earlier in the office that, you know, we're already like MacGyver here in the office. We're already making things out of rubber bands and, you know, toothpicks and paper clips and making it work. And we spent a ton of time building our budget, taking all of the ideas from the last 2 or 3 years and trying to push them forward. Holistic Resource Center, the policy people for in the field, the additional staff we need to comply with AB 480, on and on and on. And all of that was gutted. So I strongly encourage you, whatever influence you have, to please, now's the time to use that with the legislature and see if we can turn this boat around a little bit, because we're kind of at the end of our MacGyvering. I don't know. Oh, here's a positive thing. So in Lyon County, second tier conflict contract started on January 1st, and that's going really well. I think that conflict took virtually all, if not all, of our conflicts for the month of January. So that's fantastic. We also have a second tier conflict contract in Lyons starting on March 1st. So a lot of our woes there hopefully will be fixed as far as department resources and assigning cases. Elko, we're working with them still to come up with a second tier contract. Hopefully that happens soon, because that's another place where a lot of resources have been used up lately. What?
Did you want to discuss the legal server and Elko issue with the board to see if there's any sort of guidance the board would like to provide with the new information we've learned?
Sure. Yeah, thank you. I didn't know whether to go into that or not. So try to cut this short. Elko County, the Elko County PD's office in Elko County, despite the fact that they knew we were coming on board with legal server, contracted with Tyler for their case management system. Tyler was supposed to go online way back shortly after I started here, and it's still not online. So that's a big snafu. They have been entering their cases and keeping track in legal server for the time being. And I think transferring those out to conflict counsel, or we are. But what we've been working with them on for the last, I don't know, at least 9 months is, or maybe longer, we put the Tyler people, the legal server people, the PD's office, and the county IT people all together to try to create an API bridge between Tyler and legal server, so that they don't have to do dual entries, so that whatever they enter into the Tyler system, we can pull the necessary information into legal server and have uniform data reporting. So we're working on that. It occurred to us a couple of months ago that there could still be an issue in transferring cases. So how do we know if a case entered in Tyler makes it into legal server and then gets transferred if there's a conflict. And John in the IT department and some other people have expressed concerns about this, fundamentally as to whether this is even possible. There's also a third-party white box that's helping with this, so it's pretty complicated. And I guess the question for the board, maybe, and Marcy, you can help me articulate this differently if I need to, is do we continue down this road and for how much longer? Or do we just at some point say, Elko, you're not in compliance. You're not using the, case management system that you're required to by regulation, and it's, it's going on 2-year delay and making this happen at least 1.5 years. I don't know. Is that, how else would you say that, Marcy? I don't know what the remedies might be or what the board could do. Is this corrective action? I'm not sure.
So I think just to add to that, Elko has been complying with legal server, but they'd like to use Tyler since they paid for it and just have it transferred over. What we've learned is there's going to be a fee of $5,000 to set it up, plus $50 a month. I think Elko would like to pass that on as an indigent defense services expense. And I guess the question for the board is this an expense that we should be reimbursing because it's a choice that they are making? We are providing legal server for free. This may create more work for our staff because we'll have to be confirming that we are receiving accurate data from their Tyler system to legal server so that we can transfer the case to new counsel. So is there any input that the board is able to give us, because this will be a substantial cost per month, plus that initial fee, which we don't have in our budget. And we have provided legal server free of charge. And the distinction of maybe, if they were just giving year-end data, that could easily be passed over and we could easily use that. The difference is they are having at least 55 conflicts a month. All of those conflicts have to come over to our department so that we can find new counsel and assign it. And the only way we learn about that is when they transfer it to us in legal server with all the contact information and the charges. So we're concerned that if we continue to go down this road, it's going to increase our workload and increase indigent defense services expenses for not a valid reason. And I think these funds could be better used elsewhere. So if the board has any guidance for us, we'd appreciate it.
And legal server is hesitant to contract directly with Elko for this one-off thing because they're not a current client. We're their client.
Can I ask, how much longer is the contract with Tyler?
We've suggested that Tyler's in material breach of the contract. I mean, again, it was, they just keep moving the date for it coming online down the road.
Okay.
Like 3 months later, 6 months later, it's been that since I arrived here, pretty much. They're unwilling to do that right now, and I'm not sure why. This is apparently a problem with Tyler right now. I guess they're overwhelmed. We've heard this from other people in other channels. The Supreme Court rejected Tyler as a potential statewide CMS because of some of these issues. I don't know what the current date is. I think, is it June? It's either April or June right now. I have no confidence that it's going to go online at that time. And so, yeah, I don't know the answer to that.
Thank you.
So I would ask any thoughts on this from the board. I've got my opinion here, but I'd rather hear from everybody else first.
Mr. Chair, this is Chris. So we're facing a couple of issues. The fact that it's not up and running. And the other issue is whether we reimburse or the rurals or Elko. And I personally lean not, especially since we do provide it, the server part free. So I think that should be part of their obligation, but I'd like to hear some discussion on it.
Thank you, Chris. Anybody else?
And Dave, or Chair, just so you know, the EATS did have some specific concerns. They think that we need to, if we allow this, we need to clearly say the responsibility of ensuring these cases are transferred falls on Elko, because he's concerned that if there's any sort of mistakes, there's going to be finger pointing that, you didn't assign this case and we could say we didn't receive it. He's concerned that we'll need someone to verify that all cases are transferred into legal server and are able to be assigned to a conflict of interest attorney. He is concerned about exporting case data from Tyler and importing it into legal server. We have to ensure that the data is properly imported, including any times reported in Tyler. Adding any data required by legal server and then he recommends that someone maintain a log of cases transferred. And he's concerned that this could taint our statistic because Tyler's case management system needs to be able to assign a status to transferred cases so it doesn't count them when they're actually reporting those Tyler cases to them. It could cause a double counting if it was a case in Tyler that was transferred to us. So it counts as 2 cases rather than legal server is only counting as 1 because we transfer the same case from attorney to attorney. And he feels that best practices would also require periodic audits between Tyler and legal server to ensure the transfers and case statistics are properly managed. So Stan, who has had to learn legal server along with Tom, would also need to become an expert in Tyler so that we can have access to their system and make sure that this information is accurately being transferred. So these are the concerns of our EATS, and he is of the opinion that one case management system will result in the best data and the most accurate.
Thank you, Marcy.
Dave, can I jump in?
Please do.
I think that, we've been talking earlier about we're a new agency and we've had issues with whether or not, the counties are, sometimes not very happy with us. I just don't feel comfortable, making exceptions for everything right now. And so, what is Lyon County going to say? Do they, what different thing do they want? And for the client's part, I think we're most concerned about getting them their services very quickly. And I just don't see this benefiting us or the client.
Yeah, if I could just jump in there. In the beginning, in rolling this out and trying to get everybody on it, none of these people are our employees per se, and team building across the state, our approach has been more flies with honey. So we've tried to be accommodating. We decide, and I understand everything you say there, but we wanted Elko on board, and we decided that we would work with them to try to bridge this. Legal server said they could do it to get the data. And again, now we're in the situation where we've got the transfer problem, and that really is the thing that brings the red flag. So yeah, I guess it's a little bit of we'll wait and see if whatever legal server comes up with can work. Maybe, I don't know. I think we just keep moving forward, but if it doesn't work, then what do we do? I think that's really the question, the pinch point that we come down to.
Thank you, Tom. Anybody else have a comment? Okay, hearing none. I understand, having worked in the software business in my career, that once you go down that road and you sign a contract and you want to migrate a product, or it's a startup, it's the first time you've used it, it's a big deal. And they have expended a tremendous amount of time, resources, etc. So I can see why they are dedicated, knee deep in it, trying to make it work. However, having said that, I've gone through these kind of migrations before, and you're right, Tom, they may never end, and sometimes they don't work, pure and simple. and then you have to cut ties. But I don't think it's our responsibility to, I mean, we've accommodated for a long time trying to make it work. And I don't think, certainly I have no interest in paying anything to help them make that connection work. If they would like to continue to do that, and maybe they are 3 or 4 months away from going online and having a system that works, but I can guarantee you, once they go online, it'll be 6 months or longer before it actually works right. So, and this is going to be secondary to that. They're just trying to get the system to work and go online. And then once they do that, then now you're asking about, oh, now we've got to interface these two systems and bring data across a white box, like you said. I've done that too, and that doesn't work very well. So having said that, I have no interest in supporting any kind of funding for this. I would say, hey, if you can get it done and at your cost, that would be great. But in the end, we don't think it's our responsibility. And I think we've been very gracious in our time and our efforts and to work with you. That's my comment. Anybody else? Yeah.
Spot on. I first served in the Ledge in 1991 when we had the Son of Sam or whatever we call it. It was DMV. I mean, there's thus always problems with software and cleaning things all over. So there's, yeah, it's tough.
Yeah. So again, like I said, I think some requests are reasonable, but I don't think that's reasonable at all, especially since when we start talking about that, they were just signing contracts at the time. And, you know, they weren't even at that spot. So, and here we are almost 2 years later. I have a lot of friends over there, but that doesn't make any sense. I would expect you guys to, you know, to tell me where to go if I came to the board and asked you that for Humboldt County. So, but anyway, just my thought. I don't think we need to really take any action on that. It's my feeling, Tom, that that should be the response. And unless the board has some other feeling about doing it a different way, but I think it's a simple call.
Thanks, Chair.
All right. Anything else from you, Tom?
Not on the oversight. I can move to number 9 if you like.
Okay. Thank you.
Peter isn't here, but I'm going to cover the training update as much as possible. Since our last board meeting, we had the final homicide conference of last year, something that we put on in coordination with Washoe County PD, Washoe County alternate PD, Clark County PD, Clark County Special PD. And our office. So we had the last session in December of 2022. Went very well attended. Marcy, how many? Over 100, right?
I think each session had over 100.
Yeah. Our next monthly CLE is planned for February 9th at noon with Kevin Doty, who, Marcy, tell me what he's going to do. I forgot.
It's actually February 10th, and it's about what to do when the press calls. We've received, I know he put it wrong. We've received a lot of questions of how do you, as a public defender, how do you interact with the press, if at all? So he'll be discussing, you know, the right for press to have access to the courts and what public defenders can do, if anything, when they're interacting with them.
Thanks. Next thing is the 2023 third annual DIDS conference is scheduled for May 4th and 5th right now at the Silver Legacy Resort in Reno. We have sent out save the dates along with a CLE book for all of our contract holders and organized office attorneys. That is related to storytelling, which will be the theme of the conference. Do we send out the motion updates as well, Mars?
Yes, to all the rural attorneys, we've sent a motion update, which is a DVD that has sample motions on it. To the larger urban offices, we only sent the book on storytelling, which is an NLADA resource, because that's the theme of our program. So that should all have gone out to every office in Nevada, and hopefully we'll see individuals signing up soon.
We also secured grant funding again to reimburse rural attorneys for their travel expenses and their lodging. And Peter will have that application out soon for everyone to jump on there. There will be an estimated 12 units of CLE over the 2 days. The headline is going to be David Mann on storytelling for criminal defense. He's going to basically take up Thursday and Friday mornings. We'll have a Supreme Court Justice panel, again, hosted by John Lambros. And there'll be, as usual, plenty of networking opportunities for attendees. We're doing something that we borrowed from the State Bar Conference last year. We're going to do some dine-arounds in the Silver Legacy. There's lots of great restaurants there. And so our plan is to reserve tables or private dining rooms where they have it, and have different people kind of figuratively host, not financially host, each table. So if anyone on the board is interested in that, hosting a table, let us know. Anything else on that, Marcy?
We are reaching out to the Nevada lawyers, criminal lawyer, NC, what's their acronym?
Now you just made me forget.
We've reached out to NACJ. They are exploring sponsorship opportunities. Nothing is set in stone yet, but they will possibly sponsor maybe breakfast in a hospitality suite so attorneys can come up and meet each other. And Top Golf is in Silver Legacy as well. So they're exploring possibly sponsoring, reserving 2 lanes there. So individuals can go there after our dine-arounds and continue their networking. So we're really grateful for them for that, but it hasn't been finalized yet. It's just out in discussions.
Marcy and I toured a bunch of the rooms in the Silver Legacy, the Top Golf, the restaurants, and it's been a while since I've been there, but everything was top notch. They remodeled a lot of it. So for any of you who might have been a little disappointed in the plaza, this will be a step up from that. That's all I have on the training update.
Thank you, Tom. Appreciate that very much. That sounds like a great outing on May 4, 5. So, all right. If we don't have any questions on that with Tom, we'll move on to item 10, scheduling of future meetings. And April 6th, Marcy and I want to talk a little bit about that. We're not sure we really need to do that, but Marcy, I'll turn it over to you and let you lead the way.
Yes, and I think we had tentatively scheduled April 6th for a public hearing, not knowing whether or not that would be required. I think with the direction from the board that we won't be requesting to repeal, I don't think we need to hold a public hearing on April 6th. So I'd ask that we cancel that court date or not schedule anything, or sorry, cancel that date, not schedule anything for that date. And that we just keep our remaining dates of June 15th, August 3rd, and November 2nd.
Yep. Does everybody understand that? I want to add a little something to that. So on June 15th, we were talking about that being a live meeting. And the last time around, I offered Winnemucca as a potential site, and obviously would love to have you guys here and host you. Is that still the case? Are people, would they still be interested in taking the travel up north? That would be perfect time of year, great weather and the like. But I do have a question. So, and if you want to respond, we were talking about doing it on a Thursday, which is our regular day meeting. But my question was maybe people would like to do it on a Friday, that way they can, come in on a Thursday, do the meeting Friday, we can leave, and then you can either stick around and spend some time and get out and about in the outdoors, or, get you off for the weekend so that you wouldn't potentially have to go back to work on a Friday. Although Marcy reminded me, like I would do, I would just take that day off anyway. So anyway, but having said that, anyway, any comments on June 15th being a live meeting? And again, if you want to throw in something about the days, let me know that as well.
This is Chris. I think that makes good sense. Make a 3-day weekend out of it. If we decide to drive, then we got the 15th to do it, do the work at the 16th, and then people can hang out in Winnemucca and have a fast food someplace and or something.
Absolutely.
Could you just repeat though, the August I have on my calendar, what was the October one?
November 2nd.
November. Okay, thank you. I got it. Okay, thank you.
Anybody else have a comment on that June 15 specifically?
Commissioner, this is Drew. I'd support the 15th as well. I enjoyed our time we spent in Tonopah, so I think it's nice to circle the state in a variety of locations. And so if you're inviting, a Friday does make sense. Thursday's travel, Friday the meeting, and then have the weekend to either hang out or go back.
Thank you, Drew. Appreciate it. Any other comments? Jared, you're unmuted, so do you have something?
I was just going to say, personally, in terms of work schedule, the 16th would probably be more likely in June, as we'll be on the road the majority of that month.
Okay. Sounds good. So I'm hearing a theme here. Is anybody absolutely wouldn't come if it was on the 16th? Okay.
Chair, would you like to keep the scheduled time of 1 PM or would you like to move it up in the morning in case people?
I think we should move it up. Yeah, because especially if people could travel in on Thursday, we can do what we need to do and then get people out early in the afternoon so that they could enjoy the surroundings or get back home, whatever they want to do. That makes sense to me. So why don't we shoot for changing that to a June 16 date? And then the only thing I would say is, Marcy, we would want to get out save the dates and get some commitments so that I can block some rooms, get a space for us and all that. So.
Would you like a 9 o'clock meeting time, 10 o'clock meeting time? What are you thinking?
I think 9's good. As I go from 9 to 1 or 2 or something like that, I think we can do our business in plenty of time there. If we get done early, I don't think it'll break anybody's heart. So, very good. That sounds good to me. So are you set with that, Marcy? Very good. All right, so let's move on to public comment. Is there any public comment?
Nothing on my end.
Thank you, Cindy. Very good. If no public comment going once, twice, then I'll adjourn this meeting. It's 2:40. And I thank everybody very much. It was a good meeting.
Thank you, Mr. Chair. Good job.
Thank you.
Thank
Everybody have a great rest of the week and weekend. Talk to you soon.
Take care.